The Constitution requires a warrant before police can search you or your property. But what if that warrant is based on third-hand information? That's what happened to IJ client Michael Mendenhall, who was arrested for asking an unruly trespasser to get off his own porch. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Patrick Jaicomo and Jared McClain. We'll discuss how warrants are often just rubber stamps and what IJ is doing to fix that. This is Beyond the Brief. So Patrick, as a starting point, can you just give us a quick overview of how a warrant is supposed to work?
Yeah, so warrants are supposed to be a check on executive power, and they require a neutral third party, usually a judge or a magistrate, to look at evidence that's submitted and determine whether that evidence supports probable cause to issue a warrant, which then allows usually police to search or seize something. So maybe arrest someone, that's a seizure. Search, of course, look for things inside of a home. And the real idea that's captured with the warrant process is that you're supposed to have a dispassionate third party to evaluate the credibility of the underlying facts and whether they support the belief that there might have been a crime committed.
So how did that whole process go awry for Michael Mendenhall?
So for Michael Mendenhall, the process went awry because the warrant, which was submitted by a police officer, didn't provide any firsthand information that that police officer saw. What the officer told the judge in his application was, I swear that a guy told me that a guy told him that Michael did something. And so based on that sort of attenuation in the game of telephone, then the judge who's issuing a warrant has no ability to probe the credibility of those facts. And if the judge had, in a case like Michael's in particular, the strange man that was the ultimate witness here clearly would have raised red flags for the judge, but the judge didn't get that. Instead, the judge got something that had been sanitized by two levels of police officers telling police officers who were then swearing to the judge.
So, Patrick, let's talk a little bit about the facts of what happened to Mendenhall that night in Denver.
Yeah, so Michael is a business owner, and his office is in a townhouse in downtown Denver. And at the time, he and a friend were setting up this new townhouse to be this office. And it was about 10 p.m. at night. It was dark. They were just relaxing after the long day of putting things together when they heard a commotion outside, such that people were shouting, and the front doors of the townhome were actually kind of jostling. So, it's dark outside. Michael wants to go investigate, make sure that these women are okay. He walks to the front door, looks out, and grabs what's sitting next to the door, which is a commemorative all-star game baseball bat that's signed by baseball players. And he opens the door to find some strange man he doesn't know with a dog who's in the midst of some sort of discussion with these women who don't seem interested, and tells him to get the heck out of there. And then he closes the door and goes back to doing what he was doing. And as far as he was concerned, that was the end of the story. But unbeknownst to him, this man then went and called the police and said that Michael was menacing him with the baseball bat, and the police showed up, and he told them this very strange story about how he lived 30 miles away, but he was just there because he needed to go for a walk, and he volunteered that he had a loaded gun with him. And it was all very strange and didn't add up. But nevertheless, this information ultimately led to not only Michael's arrest and a night in jail, but the search of his townhouse and the seizure of his all-star bat, which the police still have to this day.
So wait, was it Michael Mendenhall who said that he had a gun, or was it the guy who he threatened or asked to leave?
The strange guy had the gun. Yeah. So that adds to the weirdness of it all. There was no concern for his own safety because Michael had the all-star game bat and this guy apparently had a gun. So it's all very weird, and it's all something that I think even on the sidewalk at 10:30 at night, you would be making the same face you're making at me right now.
Right. It's a bizarre set of circumstances, and police did no investigation before essentially arresting Michael Mendenhall. Is that right?
Right. So the police just took this guy's word for it. He came and handcuffed Michael, put him in a squad car where he sat for, the time that it took them to then call in, tell the detective what had happened. The detective writes up the third-hand story and then submits it to a judge who ultimately signs off on the warrant that allows the police to then enter and seize the bat.
So what specifically should have happened? Because if something, weird happens to me and I call the police later. I've never called the police in my life. But like if I call the police later and say, hey, such and such happened, I'm concerned about it. What you described kind of sounds to me like what I would expect to happen. So what's the kind of missing piece?
Well, so unfortunately, what I described to you is often what happens in most cases. Now anymore, police will simply write an affidavit where they say, I swear that somebody else told me. And maybe it's just that attenuated, or maybe it's someone else told me that someone told them that someone told them. And unfortunately, that is the state of affairs for the warrant process today. But originally understood, the Fourth Amendment required a warrant that's supported by oath or affirmation. And the oath or affirmation that had to be given was understood to mean you have to have a witness with firsthand knowledge who would be swearing to the facts that would then support the warrant.
But this guy had firsthand knowledge, right? So is the problem just that they didn't have him sign an affidavit?
Right. The problem is that this guy, the actual witness, the stranger here, is not the one who's going to the magistrate, whether that's in writing or orally, to say, here's what happened and why there should be a warrant issued. And if he had, then not only would the judge be able to probe the credibility of the witness, but also when things turned out to be wrong, as they were in Michael's case, he would be held accountable because he would have sworn something falsely under penalty of perjury.
So, Jared, we've seen at IJ kind of many situations where the government's sort of acting on baseless information or hearsay and then does harm to a client by, wrongly arresting them or having their house raided or other things like that. Can you talk about some of those instances?
Yeah. So it comes up a lot in our retaliation cases because there's often no reason to be arresting our clients in these retaliation cases in the first place. And so when someone's arrested for no reason, the first thing you usually do is say, well, there's no probable cause. And they shouldn't have been arrested because there was no evidence that they'd done anything wrong. And what gets the argument that we have to contend with at that point is, okay, but a magistrate signed a warrant, and that is as strong evidence as you can have that there is probable cause. And so now we're like running into this fact that there's a warrant, and what do we do about it? Because we know our clients didn't do anything wrong.
What do you mean by probable cause?
So probable cause is just that it's essentially more likely than not that a crime had happened. The police have enough evidence, enough reasons to believe that this specific person committed this specific crime. And what they're supposed to do is go to a judge and present that evidence and say, we have a really good reason to believe that Sherry Digman in Atmore, Alabama, or Cynthia Jackson in Atmore, Alabama, or Ruth Herbal in Marion, Kansas, that they committed this crime, and we should be able to search their house. We should be able to seize their cell phones so we can look for more evidence so we can prove that crime in court and eventually arrest them and charge them.
Right. And built into these concepts is that the warrant provides this very probing, violative action by the government. And so we want to make sure that before we give the government this awesome power, there's a good reason to do it. And so the process of the warrant being given is supposed to be a way for the executive to go say, I want to do this invasive thing, and then have a neutral, the judiciary, say, okay, it's justified in this case. So you're not deciding yourself whether you can just go off and do the thing. And so when we're eroding these concerns, what we're actually doing is taking away a check on executive power.
And the problem I think that creates is the courts aren't really treating it as if there's been any erosion. So the courts are still treating these warrants like a judge has looked at all of this evidence and tested the witness's credibility, and there was an oath or affirmation. So they have every reason to trust that this crime happened. And so then when we're coming in after the fact to say, hey, there was no evidence of the crime in the first place, the police are like, well, we were entitled to rely on a warrant. A judge signed off on this. So how are we supposed to know there was no probable cause? That's the judge's job to figure it out. But the judge was relying on this hearsay or this like third-hand or fourth-hand information. So there was never evidence in the first place. But then the validity of this investigation gets baked into the fact that a judge signed off on a warrant without a proper oath or affirmation in the first place.
Yeah, and fundamentally, the problem today is that this warrant process, which the founders designed, as I said, to be a check on government abuse, has now, as Jared's explaining, become a mechanism to launder accountability. So In the beginning, this was meant to be a serious bulwark against the government doing whatever it wants. But because of several different doctrines that have stacked on top of each other, today it means if you get the warrant, you're good to go. And there's basically no way to challenge it, even if you're the victim who didn't actually do anything, if there wasn't even probable cause for them to believe you'd committed a crime.
So let's start to walk through that a little bit more granularly. I know that this case is about the oath or affirmation requirement. How did we get from, at the time of the founding, oath or affirmation means personal knowledge, sworn under penalty of perjury, to today's oath or affirmation, which apparently means if someone told me that this happened, I can write it down and I can do what I want with it?
Yeah, so it's actually a pretty simple story, and we should start with the text of the Fourth Amendment, which, of course, was something that the founders put into the Constitution because one of the things that we were concerned with were violations of people's rights under things like general warrants, where the king's men would just be allowed to come in and break open whatever they wanted. As you can imagine, the colonists didn't like that very much, and relying on some cases like Entick versus Carrington, they drafted the Fourth Amendment, which says no warrant shall issue but upon probable cause supported by oath or affirmation. And then it talks about specificity required for where the warrant can be executed and against whom. But you see, there are several components that are laid out in the text. And so the question becomes, what happened to the oath or affirmation thing? Historically, for 150 years, courts understood that to mean firsthand knowledge from the witness. And I think that's embedded in the language oath or affirmation. It's just kind of strange when you step back outside of the world that Kim described today and you just think about swearing an oath. Can you swear that something happened or that something is true if all you're swearing is it's true that Keith told me something? Sure, that's I'm swearing something, but it's not to the substance of the underlying issue, which is the probable cause here. And so the way that we got to where we are is that police started using confidential informants in the mid-20th century. And I think it's simply a matter of convenience, although there's not much discussion. The Supreme Court, in a case called Jones versus United States, said that that was fine. And it did that without really getting into any analysis about oath or affirmation. It was just a question of whether relying on secondhand confidential informant information was sufficient under the Fourth Amendment. And the Supreme Court said it was. And since then, this has just spread to the point where now it's kind of such a pain to bother getting someone to sign their own affidavit that police often dispense with this.
There's two things that you said there that I think that we should dig into a little bit more. The first is the aspect of confidential informants. As I understand it, in order to have the oath and affirmation requirement satisfied, that informant would have to either appear in front of the judge or, sign an affidavit, somehow fill out a thing. Wouldn't that compromise that person's security in some sort of, dangerous situation where they're surrounded by a criminal ring and whatever? Wouldn't that put them at risk of being exposed?
So the other thing that they can do besides they could sign something, swear it out on paper, and have their name redacted. And as long as the judge under seal or in camera reviews that and thinks there's sufficient reliability, the judge could sign off on a warrant on that basis. But the judge can also just talk to someone either in person or on the phone and take their oath that way. And so we had a case in Marion, Kansas, a retaliation case where the signature of the affiant was just missing. And we're like, well, there could have been no oath or affirmation because there's no signature here. No one even swore off on this. And the argument from the other side was, yeah, but the judge called the police chief. That's you can get around filling out an affidavit by just picking up the phone and talking to a judge. And with modern technology, there's not really an excuse anymore. This isn't like the 1700s where you got to put someone on horseback and bring them 40 acres to find the judge in the middle of the night and knock on their door. We have enough technology that people can DocuSign, they can pick up a phone. There's lots of ways to accomplish it.
The other thing to keep in mind is, and the threshold is much lower at the probable cause stage, but ultimately if someone's testimony is going to be used in court, they're going to have to show up to court. You can't anonymously be someone testifying in court. And so, as I said, there's a difference between getting the probable cause and ultimately getting there, but it's on the same continuum. And so the thought of arresting someone based solely on something that will never be allowed to come into court seems problematic in its own right.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
The other aspect that you kind of both have talked about at this point is convenience. And on the one side, Jared, as you were explaining, it sounds like it's pretty convenient still for the government to get a warrant. There's all of this technology and things like that. Doing it correctly seems not that hard, honestly. Right. But I could also imagine that, the government in cases like this is going to say, oh, well, we can't be bothered to, clear all of these boxes in this rigorous way because, there's a lot of technology now and things move quickly and we have to be able to, whatever, who knows. And so how does that sort of balance out? Is there a legitimate concern here that this is overly burdensome of an expectation for the government?
I think very few cases relatively rely on confidential informants or all of these scenarios we can dream up that would make it harder on police officers. In the run-of-the-mill case, it's just the cops aren't bothering to collect an affidavit when they could, and that then bakes in this idea that the cops are probably just they're getting this information secondhand, thirdhand. No one's actually going down the line and questioning where the information came from, testing its veracity in any way. And so then we're ending up in this situation where in 80-90% of cases, cops, when they have every ability to bring the affiant forward, instead they're not. And so now courts aren't even questioning anymore, and they're able to get these warrants on much less than probable cause. Yeah, so I brought props with me today. We have a case at more retaliation. Two of our clients were school board members who were arrested for violating the Open Meetings Act. And the allegation was that these two women, because they were both members of the same government body, couldn't have private phone conversations. And that was a crime. And so
if one of them calls the other one to just have a chat, that counts as a government meeting that's supposed to be open to the public.
That's right, even though it didn't satisfy the warrant or the quorum requirement. So it was wrong for all sorts of reasons, but the one we're going to hone in on today is the oath or affirmation piece. And so they didn't even know that these phone calls were answered. They subpoenaed their phone records, and they saw that there were 40 calls going back and forth that didn't have duration. It didn't have whether they were picked up or anything, let alone the content, what they were talking about. And what the officer said was, it is believed Digman and Jackson held private conversations regarding the vote and outcome of the superintendent vote.
But they could have been calling each other just to say, what do you want me to pick you up from Starbucks?
That's right. They could have been talking about anything in the world. And even if they were talking about the vote, it would have been illegal. So we can put that to the side. But the only piece of evidence that they were talking about this vote is a police officer saying it is believed. And how are you supposed to test it? Believed by whom? Where did he get this information? Who is swearing that that they know what these two women were talking about when they were on the phone? And then a magistrate signs off on it. But then going further, they then accused Cynthia of a second crime, and they said it has also been reported Cynthia Jackson has made public statements about a grand jury. It has been reported by whom? Who did she make these statements to? Was she a member of the grand jury? There's no evidentiary basis here. There's no one who can actually swear that a crime happened. They're just saying, rumor has it, Cynthia's done some crimes. We need a warrant to go seize her cell phone and download all of the information off of it.
So this is almost a step beyond hearsay. At least in most kind of traditional cases of hearsay, it's Kim told me that something happened. But here, they're not even saying who told them that this is happening. They're just almost stating it like a conclusion.
That's right. Yeah.
So is this sort of failing of the magistrates? How do you get every magistrate in the country to every single
to do their
warrant
job?
that comes? Well, sure, yeah, that's to not put too fine a point on it or anything. But how do you fix this, I guess, is the question.
I think the Fourth Amendment, overturning Jones versus United States and making the oath or affirmation requirement, which is right there in the text of the Fourth Amendment, you make that mean something and make judges have to actually believe that this person who's coming forward with some evidence has some firsthand knowledge and knows what they're talking about, I think that would be a very good starting point because, like we were saying before, once this warrant's signed, our job to prove that there was not probable cause becomes that much harder because a judge has now signed off on it, and that now has like this sense of official and like someone gave their considered judgment to this, and a judge really believed there was probable cause. So now it's up to us to show that there wasn't, instead of everyone should be able to look at this and know that it violates the Fourth Amendment.
So other courts are treating it as though it still sort of went through this rigorous process and cleared all of these hurdles, even though it didn't. So it's kind of like built on this foundation that doesn't exist.
And police officers are entitled to rely on it because it has a judge's signature. And so that's the laundering that Patrick was talking about.
Yeah, let me actually explain the laundering piece a little bit more. So if you're the victim of a completely made up story that results in your house being searched, you think about it, okay, your neighbor doesn't like you. So he calls the police and says to the officer, Jared did something bad. The officer then calls another officer and tells him that Jared did something bad because this guy told me that. The guy himself, the neighbor, he's off the hook because he told the police the thing, but that's not where the swearing happened. The officer who actually swore to it, he was telling the truth because the second officer told him something, and he's saying that officer told me something. The judge signs off on it. The judge is going to be immune because of judicial immunity. And so at every step in the chain, there's no one to be held responsible. And as Jared pointed out, there are things like the independent intermediary doctrine that say police can rely on a warrant unless they know or should have known that there's a material misstatement in there or some other different ways of sussing it out, but it's extremely limited. And so all of this results in, again, the Fourth Amendment going from being a genuine protection of people's rights to it just being a way to say, if you do this quick box checking exercise, you'll be covered from any sort of liability if and when you violate someone's constitutional rights. And I also wanted to go back really quickly to the idea of convenience. Jared's right, of course, that in the mine run of cases, there's no need for this sort of convenience, but with technology and everything else, there's really no additional problem being created here. If you can just have the person themselves sign an affidavit on paper or even on your phone, a lot of times these warrants are being issued through apps where it takes, on average about 20 minutes or less for a judge to sign off on a warrant. And of course, there are already all these different doctrines built into the exceptions to the warrant requirement. And so if there is genuine exigency, for instance, there will be situations where you don't even need to get a warrant before you do what you do. And so there's a ton of other stuff that's already built into the system that means that adding this on top now takes the Fourth Amendment's protection from being kind of limited to being basically gone.
Yeah, and the example that you just gave, it seems like the part that's missing is when, Jared's neighbor calls the first police officer, that police officer should send him a form saying, write that down and sign it and send it back to me. And then he gives that to the judge, right? Like, that's the only thing that's missing here.
Right.
Or the judge kicking it back and saying, hey, cop, go get that guy to write it down.
Exactly. Or the guy could just get on the phone with the judge if the judge wanted to hear from him, or through these apps, that person could be the one that's signing the affidavit in the warrant page of this app. The bottom line is, it seems like any objection to this is mostly an objection that police shouldn't have to do the most basic due diligence by ensuring that you're connecting directly the dots of the complaining witness to the support of the probable cause to the issuance of the warrant.
To kind of root this back briefly to Michael's case, so this stranger who made these false allegations of menacing, was he ever punished? Was he ever, were there ever charges for, filing a false police report? Or did this guy just kind of disappear into the mist after he leveled his false charges and walked away?
Yeah, I mean, he was out for a walk that night, 30 miles away from where he lived. And as far as we know, he was able to walk back off in that direction without any consequences. And so that night, whatever happened with the women, we don't know. But he was in some sort of altercation. And the result of that altercation between him and other people resulted in Michael being arrested and spending time in jail and having his property searched, while this guy was just allowed to let go with his loaded gun and his dog to walk off down the street.
Yeah, if I could give one more example, we have a North Carolina SWAT case where it was a wrong house raid case. This family's asleep at night. SWAT team shows up. The evidence that the police had that they were at the right house was that they said the suspect's car was parked in front of the house. The suspect drove a 2007 Sentra that was dark gray. Our clients had a 2017 Altima that was silver. They're different
Sounds
cars.
identical to
yeah,
me.
different license plates, different registration. But one cop told another cop that's the suspect's car. So then the second cop, who has this secondhand hearsay information, signs a warrant application that says the suspect's car is in this driveway. Wrong house raid ensues. Our clients are traumatized. We bring a lawsuit. The affiant, the police officer who signed off on the warrant, his first defense that he makes is, I was entitled to rely on another police officer's observations. The first police officer says, I didn't make any material representations because I didn't sign a warrant. And all of the other police officers say, well, a judge signed off on that warrant, so we can't be held responsible for what happened, and the judge is immune. So now there's just this chain of screw-ups where someone confused a gray 2000 Sentra for a 2017 silver Altima, and our family gets traumatized, and all the cops say, well, no one can be held responsible because no one swore to any information that they personally knew, and that's the problem in the first place.
Well, and it's also the reason why hearsay isn't typically admissible in court. You
Right.
know, like, I mean, you learn this in law school, that when you can't question the person who has personal knowledge, when you just are relying on, out of court statements, that there are lots of kind of normative problems with that.
Yeah, and I also think to Kim's question earlier about, how will this fix the problem if the magistrates aren't really paying that close of attention? I think that if the Supreme Court were to weigh in on this and revive the oath or affirmation requirement, that would send a very strong signal to every magistrate in the country that, no, this actually does mean something and you should start taking a look at it because this is serious. This is fundamental to, who we are as a nation.
And that reminds me, Patrick, earlier you mentioned that I think maybe on average a magistrate takes less than 20 minutes to review and sign a warrant requirement or a warrant petition. I don't know where you're getting that from, but is there data on, for example, how frequently warrant applications are denied versus granted?
So I'll say that the data that I'm using is from a private company called Cloud Gavel that offers an app-based warrant service that a number of government entities use, and they brag that the average time to wait is 20 minutes. But there are examples where these warrants are being issued after 2 minutes.
Well, so that 20 minutes isn't even like 20 minutes that the judge is looking at it. It's the judge gets an email and then maybe 19 minutes later opens the email and then just goes boop.
It's 20 minutes from submission to approval. And so that in and of itself seems obviously very problematic. In terms of the statistics, I don't really know. I think it's clearly much more common that warrants are going to be approved than disapproved. And there are a number of other things that are sort of informal to the process. For instance, if there's a judge in your district that gives things a much closer look, you're going to go to the easier judge. This is not a panacea to solve every single problem, but it is a way of restoring one of the core pieces of sort of the machine that the founders designed to help protect us from these sorts of government abuses that now we've all kind of unfortunately gotten used to the point where you can tell, normal people about this and their first reaction might be the one that I think Jared and I have, but it could also be one where they say, well, you know what? I think that seems reasonable, and it didn't seem reasonable to the people that wrote our Constitution, and I think we need to revisit the debate that led to the language that was ratified in the Fourth Amendment.
So sort of wrapping up, I'm wondering if you guys can kind of put this, oath or affirmation issue into the context of our broader Fourth Amendment project, because it occurs to me that we have all of these cases saying, officers should have to get a warrant. Law enforcement should have to go get a warrant to enter your private property, even if it's technically a, open field. They should have to, get a warrant to do all these things. What it sounds like what you're saying is that those warrants kind of, don't really mean anything, right? And so why is it significant that we would stand so firm even on the ground of you have to get a warrant in the first place if that's just kind of a, rubber stamp kind of process?
I think fundamentally the answer is if you take the text of the Fourth Amendment, which anybody can read, it's not a lot of words, and you kind of highlight the different clauses that are in there and you color them from green to red, from good to bad as far as whether they're being actually enforced. Our goal with the Fourth Amendment project at the most basic level is to get all those words to turn green. And it might be the case that just getting the oath or affirmation to turn from red to green is not going to solve all the other problems. But as I mentioned earlier, this is a machine that was designed with several parts by the founders, and we need to get all the parts working again. And so what we shouldn't do is kind of view every one as if it's making or breaking the system and say, well, what's the point of the oath or affirmation clause because there's still this problem or that problem? Well, we can fix those problems too, and we will. We will continue to fight that fight. But the goal is to turn our Bill of Rights from red to green, and then we can discuss as a country, is this good policy or bad policy? Is this outdated? Does this need to be updated? And if it does, then you can go through the amendment process and make those changes. But what we shouldn't do, and what we have done as a country, unfortunately, is watch the language that has been ratified turn from green to red over the last 250 years.
In terms of accomplishing that goal, I've noticed a pattern with Fourth Amendment cases is you have this really strong, historically grounded interpretation of the Fourth Amendment that about 60 years ago kind of goes away. And it goes away really for policy reasons. Courts who are saying, well, we want to make it easy on officers to do their jobs. And so they kind of start picking around the edges. And now we get today's kind of watered down Fourth Amendment. How do we feel about, the current judiciary? And, I know that there's been a trend in the last 2 decades or so, maybe going back a little longer, of leaning more on history and tradition. How do we think that this tension is going to resolve itself with the Fourth Amendment? Because we have kind of a policy-driven Fourth Amendment now, but what we're asking for is that historically grounded Fourth Amendment.
Yeah, it's an interesting question to apply this sort of like history and tradition analysis to the Fourth Amendment, because I think what was allowed and what was not allowed is a lot easier to trace just through the case law, because there was just a change over time, and you don't necessarily, it's not sort of like the regulatory space, like regulating firearms, where you have to go look at all of these codes and figure out how different cities and towns were regulating firearms. It's just like what police were allowed to do and weren't allowed to do. And there were a couple like sea changes. The first one was during Prohibition. There was just this idea that like if you couldn't pull over cars and like cut out the upholstery and see what was beneath the seats, that we weren't going to be able to stop rum runners. And so the court was like, yeah, okay, yeah, automobile exception, let all of this stuff go. And then you get to the war on drugs and it starts happening again. And I think what we need to do is just sort of rewind back to how the common law and the case law worked and how everyone understood it to work. And it's not necessarily this like fine-tooth looking over different codes and statutes and what practice was at the time, the same way it was with some other amendments.
Yeah, and I think there's much room for optimism on this score, because in the last few decades, the Supreme Court in particular has been very willing to revisit Fourth Amendment issues in light of original understanding. And so we've seen some sort of large cases like Torres versus Madrid and Lang versus California and a number of others, where the court has said, okay, well, this is how the law has crept away from its original meaning, but we're going to return it. And there has been a lot of, infighting by the court on what the original public meaning might be. But fundamentally, the court's starting premise is that's what should control. And I think the optimism for a case like Mendenhall is the oath or affirmation stuff is very clear. And it's also very clear that it's been completely deleted, essentially, from the Fourth Amendment. So it's obviously always a tough ask to go to the Supreme Court and say, hey, would you mind not only overturning your 65-year-old precedent, but also doing it in a way that will at least draw some ire from the rule of law police officer side of the discussion. But the court has shown itself to be willing to do that and has been very protective of the Fourth Amendment and in its requirements and decisions over the last few decades.
Yeah, I mean, I want to slightly push back on you saying that the kind of like, Keith, react.
I know. I'm not used to this.
that opponents to this would be the kind of rule of law people, because this sounds like what rule of law is supposed to be, right?
Yeah, I think that's fair. I think maybe the better language would be tough on crime.
Sure.
Rule of law, I think, is really what we're about and what we're trying to accomplish. It's just that phrase gets co-opted by anybody who wants to use it. And so it depends whether you mean rule of law with a trademark sign behind it or rule of law as in the sense of its also original understanding.
Yeah, and like going back to the Atmore case where they're getting warrants on it's believed and we have reason to believe and it's been rumored. Like our theory of that case is that the sheriff and the prosecutor in that town, they thought that they were the law, and anyone who disagreed with them was violating the law. And we're not talking about the Constitution or codified statutes. We're just talking about offending the top lawmen in town in these small towns. That's what I think some people mean when they say rule of law versus what the laws actually say, what the words in the Constitution actually say.
Thanks so much, guys, for coming in and talking with us today.
Yeah, happy to be here. It was a lot of fun.
It was a great time.
And thanks to all of you for watching. If you'd like to learn more about IJ's work to end government abuse, you can like and subscribe to our channel. And if you want to support this work, you can join our more than 12,000 supporters with a gift of just $5 a month at ij.org/monthly. Thanks so much.
Thanks again for watching. Make sure to like, subscribe, and tune in for more videos.